there's a Latin term that I hesitate to even try to pronounce. I think it's I'm looking in my book because I have it written phonetically so that I can actually say it. It's damnum absque injuria, and that's injury without recovery. So if you have property that's damaged without a physical invasion, then that's what courts in Florida refer to as damnum absque injuria. And so the key is to look for that physical invasion. An example of this is this case, Patty versus Town of Palm Beach. In Patty, Palm Beach constructed what they kind of put quotes around that because I think that's a very unfortunate term to use. They constructed a groin, which is effectively like a jetty, but it's filled with sand. And that groin changed the action of the ocean, and it caused erosion on the plaintiff's land. And in that case, the court ruled for the town of Palm Beach, saying that Palm Beach hadn't actually invaded the property. Now, they had done something that affected the property, but they hadn't actually invaded the property. So that's an old case. I'm not sure that it would still stand that way today, but I think it's a good example of the difference between government action affecting private property and action invading private property. And also in line with the taking versus damage cases, State Road Department versus Darby is a case that gets cited a lot. You hear about it a lot. It's and this has to do with, it's a pretty short opinion. There was a fill that during the course of some road work, private contractors had caused fill to go onto the plaintiff's land. And the term that you get from Darby is damage necessary incident to the prosecution of the work. And in this case, the court ruled for the landowner, saying that even though it was done by a private contractor, the government needed to acquire the place to put the fill in order to do the project. And so that's where you get the government must acquire the necessary interest. You hear this comes up in the temporary context for temporary construction easements, driveway harmonization, things like that. If they're affecting the property for that temporary period of time, and it's something that would have been necessary for that project to be completed, then they needed to acquire that. And this is an issue. Darby's an issue that I'm dealing with very currently. I don't think it's with anybody that's here today, but it had to do with they're putting a municipality here in the state was putting in sewer lines, and in the course of putting in the sewer lines, they ended up parking their equipment and trucks and such on a landowner's property for a period of about 2 months that they didn't condemn the landowner's property for. They just parked there. And the guy was showing someone he recently bought the piece of property. He was showing a friend, hey, look, this is a piece of property. But he comes by, and there's a bunch of stuff on his property that he has no idea why it's there. He tells them, hey, you guys need to get this off. And when they do that, the foreman says, look, we need this property. We can't do our project without putting our equipment and vehicles here during the course of the project. So that comes up, and of course the municipality says, well, they were there by accident. That's not where they were supposed to be. They're supposed to be on our property, and so that's ongoing. But again, you see, if they needed it, like they say they needed it, then they also needed to acquire that interest for the project. The public purpose argument. This is something that came up in one of our cases where, and in Kirkpatrick, which is a great case, the government said, well, we took the property, but we didn't do it for a public purpose. It has to do with an invasion. They said in Kirkpatrick, yes, we invaded the property, but it serves no purpose for us. So therefore, no cause of action for inverse condemnation can lie. Well, of course, the court disagreed and said, look, it doesn't matter whether it was for a public purpose or not. You invaded this person's property, you permanently damaged it, you need to compensate them for it. Now, I said it might be a different scenario in takings cases because, I'm sorry, in these temporary cases, because to me, the public purpose is kind of the crux of the issue between the difference between a trespass and an actual taking. Why were those vehicles on the property? Were they there for a public purpose, or were they there to eat lunch, which obviously wouldn't be for a public purpose? And I think that's kind of what Hendler gets to, and there's also another case we'll talk about, Edwards Dairy, here in a second. Immunity considerations that come up in these sort of temporary physical invasion cases. Law enforcement is one. It came up in a law enforcement case for us, and those are, a lot of them have to do with firefighters, and firefighters come in fighting fire in an adjacent piece of property. That typically is not a scenario that's going to be covered in a temporary physical invasion, and in fact, there's really no hope of any kind of recovery and inverse condemnation in those cases. Sovereign immunity is very important because it applies to the trespass but not to the takings. And if for some reason you were to file a lawsuit and inverse condemnation for a temporary purpose, and you wanted to include a count for trespass, you've got to strictly follow 768.28, or you're going to have a lot of problems. Also, we have people who call our office about surveyors and engineers trespassing on their property. There are statutes that allow them to do that. So that's just another, those are immunity considerations. Surveyors and engineers are allowed to enter onto private property to conduct their business. They're not allowed to damage the property while they're there, but they're often covered, and so that's something that we have to tell people. So what's the answer? What is the difference between the tort and the taking? I think there's 4 cases in Florida. I wouldn't say any of them are perfectly on point, but I'd say that we have to draw a little bit from each of them. These are the 4 cases. The 1976 Kenworth tractor trailer truck is really long. That's kind of synthesized down. And you can see here Associates of Meadow Lake, White versus Pinellas County, and Edwards Dairy, Inc. The Kenworth case is an interesting case. It has to do with private property. It was a truck that was impounded for a period of 2 years, and the government argued that the plaintiffs only claimed that the plaintiffs filed an inverse condemnation claim for recovery of the value of their truck during the time it was impounded. And the government in that case argued that plaintiffs' only claim would have been for a tort and couldn't have possibly ended up in an inverse condemnation claim. Well, in that case, the court rejected the argument and said that they actually had raised a meritorious takings claim for the time that their vehicle was wrongfully impounded. And so I think that that's very instructive if you use that and build on these other cases. The next one would be Associates of Meadow Lake. It's a flooding case. It was decided after First English, like I said, was when we kind of first had the articulated temporary taking standard. The trial court found no taking there because the city had remedied the flooding. Flooding no longer existed. There could be no taking, and that was the trial court's decision. The 5th District said that they disagreed with that reasoning and said that the landowners were entitled to compensation for the denial of any reasonable use that occurred from the flooding. And I think if you look at that, you apply the public purpose. There was a public purpose for the time that they flooded. That case, I didn't put that in there, but I think they found it was during an emergency, so they were flooding it for a